listening to Driving Law, a podcast by Kyla Lee about all things related to the rules of the road.
Hello, and welcome to another episode of Driving Law. I am Kyla Lee, and with me, my distracted co-host, Paul Doroshenko. Reading something.
Distracted.
You were looking at your phone.
Yeah, but I don't need to listen to the intro. I know the intro.
Okay. Well, maybe the intro, I would shake it up and do something you weren't aware of.
Consistency is important, Kyla. It's good to have a consistent intro. I like your intro. I try and, when you're not there, I try and do my best impersonation or recantation or recitation of it.
Okay. All right. So we've got a couple things to talk about today. There's been actually like a lot of driving law related cases in BC and otherwise in the last little while. So lots of kind of new stuff to deal with. The first thing,
Cases in the news we can't comment on.
case in the news we can't comment on.
Cases in the news we can't comment on because we've been contacted sometimes, or we've got some side connection to it. There's been so many cases this week, and you had a bunch of successes in IRP hearings.
Yeah, I had a crazy win week.
Yeah.
That was good. All right, let's talk about obstruction. Because you and I have talked about this before. And like in particular, what happens when you're pulled over, the police are investigating you under the Motor Vehicle Act, you refuse to state your name. Should that give the police grounds to arrest you for obstruction? Or should it just be a ticket under the Motor Vehicle Act?
Well, they have to be able to identify you, and if you refuse to give your name ever, I think they have no choice but to. But if they arrest you and then you give your name, I think it should be a ticket. So we have a new case, or what do we have?
Yes. So the BC Supreme Court dealt with this. This is Mr. Embleton, who was self-represented, appealed his conviction for obstruction on the basis of a number of reasons, many of which had to do with his status as an entity and not a person who didn't enter into a contract with the government.
Filed his own appeal.
Yeah, well, nobody's representing him on the organized commercial pseudo-legal arguments. But there were some like meritorious issues to address in the appeal. So Mr. Embleton rather, was pulled over in February of 2025. He was not displaying a license plate. He had made his own license plate. Remember, he's not in a contract with the state. So he made his own fictitious laminated paper license plate. Constable Craddock pulls him over, sees that the truck also has a number of physical defects: no rear window, cracked windshield, it's uninsured. Again, doesn't want to enter a contract with the state.
I think this one was on the news when he was pulled over.
Oh, probably. And then he identified himself only by his sovereign names, Peter William, but didn't provide a surname, which, those are his first and middle names. So there might have been enough information to identify him in terms of like looking up the vehicle itself based on the VIN. Who
might be able to determine it right there.
Yeah, but of course he was self-represented and he was making his organized commercial pseudo-legal arguments and not thinking that maybe there's an actual legal issue there. But
yeah,
always a good idea to get a lawyer. So he was initially processed by the police as John Doe. He had no prior criminal records. They couldn't find him in the fingerprint database, and they eventually determined through investigation his legal name. So he actually had a bail hearing, like as John Doe. And then he was ultimately released on conditions, including that he attends future court dates. But then he refused to sign his release document because it didn't incorporate conditions related to his sovereign status. So he ended up staying in custody. And then a different judge was like, yeah, I'm going to dispense with the signature requirement. This is ridiculous, and let him out.
Yeah.
So he spent like 11 or 12 days in custody. And
Just to not give the name that he was given by his parents.
Yeah. And so he's charged with this obstruction charge. He's already done more jail time than he would have had he just, I don't know, pled and got a conditional discharge the first time around.
Yeah.
Uh, and he refuses to identify himself at his trial in August. Identifies himself by saying that he's appearing by special divine appearance, which I'm pretty sure is only reserved for when Jesus comes to court. Special divine appearance. So because he refused to identify himself as the person named in the charge, the person named in the charge didn't show up to court, and the judge was having none of this stupidity and issued an arrest warrant for Mr. Embleton, who was promptly arrested then and there because that was clearly Mr. Embleton. The sheriffs got his expired passport from his pocket. And then they released him so he could participate in the trial at the council table, and ultimately was found guilty of obstruction. So he advances 4 issues on appeal. The first one being that the judge erred by misapprehending or improperly excluding his evidence and materials concerning his asserted political and legal status.
Yeah, that one is not going anywhere.
That was like a one-line dispensation with that ground of appeal. Nope.
Yeah.
Did the trial judge err in concluding that the essential elements of obstruction were proven beyond a reasonable doubt? Do the appellant's allegations concerning self-representation, charter violations, detention conditions, or procedural unfairness disclose any basis for appellate intervention? Which, I'll pause there. Nothing happens in those grounds because they're like nonsensical, but it's interesting that, these people are willing to resort to the charter when it's to their advantage.
Yes.
It's like all of a sudden, oh yeah, no, I like the Constitution right
There
now.
is a law. There is a law I like. There's a law I would like to have benefit me.
Yeah.
Otherwise, I don't recognize your law.
And then there was a question of whether his sentence was appropriate. And he did get a conditional discharge with a year of probation, 40 hours of community work service, and a prohibition from providing information on these, sovereign citizen things to anybody under the age of 19. It's basically like, stop the bleeding. I like that condition.
Yeah, not bad. The only problem is that he's a guy who will never abide by any conditions. Probably would have been better off just if given him 2 days in jail, time served.
Well, who knows?
But it's a criminal record.
Yeah, anyway, the
And
court,
in conditions that are not a criminal record.
yep. The court very quickly determines that no, the judge didn't actually even have to bother to consider his stupid pseudo-legal arguments, because as case law have said, the judge is entitled to basically say, these have no legal effect. Moving on. And then the issue with the obstruction is the real issue, because he actually does raise partly the right argument. Specifically, this dispute about whether it should just be a traffic ticket or whether it should be something more. And he even had like the cases on it. So the court goes through the sort of mens rea. You have to have the willful intent to obstruct, and whether his sincerely held beliefs that he is not a person are somehow negate the willful intent for obstruction, which the court's like, yeah, no, you can't obviate the obstruction offense by
Having unreasonably held beliefs.
having, honestly held but unreasonable beliefs. Like your ideological justification doesn't negate your intent to obstruct. You were aware you were obstructing the officer in his duties. Whether you believed he had the right to do it or not is separate and apart. And then he gets into this issue of the use of the criminal code for the violation of a regulatory offense. And the court notes the case of Yusuf and the case of Hattie, both from Ontario and Alberta, respectively, where he says that those cases stand for the proposition that the police should have proceeded solely through the provincial regulatory enforcement mechanisms rather than by way of criminal charge. But the court concludes that those cases are not specific enough to assist him, and that each obstruction case is highly fact specific, and they're also governed by different statutory regimes. Um, and police cannot use the obstruction offense, the court says, simply as a means of compelling compliance with a regulatory requirement where the governing legislative framework already prescribes an appropriate enforcement mechanism. And it's, you hit the nail on the head there when you said, well, yeah, but you have to be able to identify the person in order to issue them a ticket. So, like, obstruction for not getting out of a car, maybe failing to follow the direction of a peace officer, but obstruction um, for not identifying yourself, there's no enforcement mechanism under the provincial statute because you need to know the identity of the person to fill out the violation ticket.
Well, there's a statutory obligation to identify yourself. And that is so they could fill out the ticket.
Yes. Yes. And determine who's driving the vehicle to investigate insurance and things like that too. But yeah. Yeah. So the court concludes that viewed in that context, it was not a case where the police merely resorted to the obstruction offense as a substitute for an ordinary regulatory enforcement. The conduct intentionally interfered with the lawful execution of the roadside investigation and enforcement process. Um, yeah, the court then looks at the condition, the strange condition on his sentence, and finds that it's just fine. It doesn't permit him or prohibit him from holding the beliefs or engaging in his, lawful practices or discussing ordinary political or philosophical matters. Didn't prevent him from continuing involvement in youth activities or mentoring students. It dealt with one specific type of conduct, disseminating that pseudo-legal nonsense
Bullshit.
to minors. And that's it. And the court finds that's a sufficiently precise wording. It's not impermissibly vague. It provides adequate notice of the prohibited conduct, and it doesn't constrain his rights in enough of a way to be an unenforceable condition.
Seems fair. Yet another sov-sit case
Yep.
in the long lineage of sov-sit cases. If I ever lost my nut, or if I ever decided I did or was thrust upon me that I wasn't a lawyer anymore, I'd be tempted to write the sov-sit Bible because I could come up with some great pseudo-legal claptrap.
Oh, I bet you could get AI to just like persuade you of all of that stuff these days.
Oh, I'll bet. Yeah, you probably could start talking to it and it'll start feeding it back to you.
Yep.
Say at the end, one note though.
Some cases have been critical.
Yeah.
All right, so that's our first case. Our second case for today is dealing with the issue of failing to stop for the police. We're all about obstructing the police today, Paul.
It's the police obstruction special.
Yeah. Um, so this is that sort of unique situation, and you know the types of files I'm talking about, where the police, they see some driving, they're concerned about it, they pull the person over, the person comes to a stop, and then before the officer gets out of their vehicle, before the transaction is complete, at some point during the time from when they stopped to when it was gonna end, they take off.
The most entertaining ones for me are where the person has given the police officer their driver's license.
Yeah.
They take off.
Yeah. That's when
Already been driver, they've already been ID'd, and then they take off.
Yeah, but that's when there's like bodies in the trunk, and they'd rather get the flight from police down the road or the obstruction down the road. I'm giving it away here. Than get charged with whatever it is the police were about to discover.
Not always, but
Oh,
sometimes people just freak out and decide that they should leave.
sure, that's true too. But I'm always skeptical. In any event, this is the case of Adamu. It is a BC Provincial Court case, 2026 BCPC 142. And in this case, actually, the lawyer on the case has just recently been appointed a BC Provincial Court judge.
There you go.
Yeah. So,
Lawyer right.
yes. Constable Toe is hanging out, and he sees a Toyota Corolla pass his vehicle in excess of the speed limit. He queries the vehicle, learns the vehicle's a rental, pulls behind the vehicle, waiting for an opportunity to conduct a safe stop, sees the vehicle like going over the solid yellow line to go around a vehicle. And then he activates his lights, pulls the vehicle over, and the vehicle comes to a stop. He gets out of the vehicle. He approaches the driver's side of the Corolla. The window is down. He tells him he stopped him for speeding and crossing a solid yellow line, asks for his license. The driver says he's nervous. He's stuttering and his hands are shaking. He reaches under the driver's seat, pulls out a black shoulder bag, and then doesn't get his driver's license, reaches down to the stick shift, moves it into drive, and takes off, making a U-turn and going away. And the officer is kind of like befuddled that this has just happened, doesn't exactly know what to do, takes a pause and thinks, oh, shit, okay. So he goes back to his police vehicle. He broadcasts to the other officers what had occurred on his radio. And broadcasts a description of the vehicle, license plate, description of the driver, and doesn't attempt to pull the Corolla over again.
That's the right thing to do. This is good thinking police officer there.
I mean, it is the right thing to do from like a pursuit policy perspective, yes.
Yeah.
So then the information gets out, and about 12 kilometers away, Constable Bring locates the vehicle and locates the driver, and he ultimately gets dealt with. So he ends up charged with dangerous operation as well as flight from police. And when Constable Bring, the second officer, locates the vehicle, he says that he sees it traveling on Dudney Trunk Road, follows it. It's observed in basically normal driving behavior, other than it's changing lanes several times to pass other vehicles. But he was going between 50 and 70, which is, normal speed. Traffic volume is the normal traffic volume. Nobody had to brake or swerve to avoid. And it travels through an intersection and runs through a red light that had been a stale red for a few seconds.
It's dangerous.
You'd think. And so he ultimately he gets through the intersection, follows it for several kilometers, and again it continues to drive normally until ultimately the police are able to box it in, because they're not going to try and conduct another traffic stop. Yeah. And so he's charged with this failing to stop, and the court raises the court considers the question of whether this is actually failing to stop. That the mens rea requires proof beyond a reasonable doubt that the driver acted deliberately or was willfully blind to the pursuit of the officers. And the actus reus is that there must be an actual pursuit, which requires that the police be following the vehicle with the intent to stop it from driving away. And so
So my point earlier is creating a defense.
Yeah, if they don't follow the vehicle with the intent to stop it, there's no pursuit. And if there's no pursuit, there's no actus reus. And the court looks at a number of authorities in that sort of sequence and adopts a case called Akufo-Duncan, which is a 2026 decision out of Ontario. It says a pursuit requires the police to follow a vehicle with the intent to stop it. If the police do not follow, there is no pursuit. A traffic stop does not constitute an ongoing pursuit.
Yeah.
The mental element requires knowledge that one is being pursued. Knowledge that one is being stopped is not the same as knowledge that one is being pursued. Knowledge must exist at the time the driver fails to stop. Knowledge of being pursued can be imputed from the context surrounding it, but only if an actual pursuit follows. The meaning of pursuit is to follow with intent to stop or overtake, and the meaning of pursuit must respect the statutory text and maintain its everyday and ordinary meaning. And so the court adopts that reasoning and finds him not guilty because he didn't commit the offense.
That's interesting. Yeah.
Yeah. So then the dangerous driving And looking at the marked departure question, and you correctly identified the red light as being the possible dangerous driving. The court cites the Mashfegi Zadeh case from the BC Court of Appeal, one that we talked about with the yeah, with the red light running. And the court says, at paragraph 53, the Crown relies almost exclusively on Mr. Adamu's act of running through a red light to ground the dangerous driving charge. Although the Crown suggested that some of his prior driving, which involved multiple turns onto different streets, might be characterized as him driving in a way to avoid the police following him, that is at best speculative. Constable Bring did not attempt to characterize the driving in that way. While the Corolla was seen as changing lanes several times, Constable Bring did not suggest that it was inappropriate for him to be doing so. Indeed, this occurred over a period of 30 minutes at a distance of 11 to 12 kilometers. It would not be unusual to change lanes several times over that distance. 30 minutes earlier, he was seen by Constable Toe crossing a solid yellow line and driving at a speed higher than the posted limit. While possibly illegal, these actions do not add much to the dangerousness analysis. Driving through a red light in a significant intersection during the day is dangerous to the public. So that satisfies the actus reus. And the court says it's not a marked departure because there was no evidence of vehicles or pedestrians in the intersection. The traffic was not particularly heavy. It was also not particularly light. It was evening. It was dark outside. The roads were dry. The vehicle didn't have to swerve to avoid other vehicles, change lanes, or change speed when proceeding through the intersection. The light had turned red well before his vehicle entered the intersection. The balance of his driving while being observed for approximately 30 minutes was unremarkable. And the court says that they're unable to conclude that his driving fell at the higher end of blameworthiness and was a marked departure, and so the mens rea was not made out. I think that's
Driving through a stale red light, as we know, is not necessarily dangerous driving if
yeah, no, but
it's
it's
done
not.
intentionally.
But it was done intentionally, seeming.
How do you know? You don't even know. I mean, the guy could be so distracted by the police behind him that he drove through a red light.
Yeah, geez, I took off from the cops earlier. I wonder why this guy's not stopping me. Maybe. I don't
This
know.
is hilarious because I can think of other things he could have been charged with, including obstruction.
Yep.
But it also speaks to a need for a Motor Vehicle Act amendment about remaining at the scene of until the police have released you. And same with potential criminal code amendment for that purpose. You know, when people are being issued an IRP and the police officer has made the decision to go IRP, there's absolutely nothing there in law that requires that the person stay. The moment the police officer has made that decision, they've got a fail on an ASD, they've read the person the notice of driving prohibition of 3 months. At that point, there is nothing in law compelling a person to stay there, which doesn't make a whole lot of sense because they still have to be served paperwork.
Mm-hmm.
And just like when you're pulled over, like you pulled over, you're stopped, you provided your license.
Yeah.
So long as they're not pursuing you, if they're pursuing you, then stop.
Yeah. I mean, it's a great case for the defense.
Yeah.
I suspect that there is a Crown appeal coming.
Yeah.
Crown will probably appeal both acquittals. And I think that the Court of Appeal may not follow the Ontario line of authority, may say, no. Like, you have to look at it in context, and the pursuit can be like failing to stop and remain stopped, because stop doesn't just mean stop and then keep going. Like, how could that not be criminalized?
Just a hole in the law. It's not specific. It's not an offense.
Yeah. Anyway, fascinating, I think.
A good one. Yeah. Well, it's a great decision for that lawyer's last decision as a lawyer
Yeah.
for him.
Yeah. Now,
The ridiculous driver of the week.
this week is not somebody who's obstructing the police, but still somebody who's pretty darn dumb. So this person is in Ontario, and he is sitting in the open trunk of an SUV, and essentially the driver gets charged with stunt driving, but the driver is driving this guy who's sitting in the back of the open trunk, and then there's two sports cars, fancy cars, driving behind the SUV, and he's sitting there with the hatch open for the purposes of filming them while they're in motion on the highway, Highway 417.
Yep. So the back of the SUV open, guys hanging out the back, sitting in the back, filming these sports cars. Yeah, it's so ridiculously dangerous and stupid.
Yep.
Also, you can buy all sorts of mounted cameras now. You might not get the exact perfect footage you want, but people do it all the time.
Yes. Anyway, he ended up charged with stunt driving. I think he got like a $2,000 fine, 6 demerit points if he's convicted. And
What
he also got
punishment for the camera person?
there's no punishment. Oh no, he was. Yes, he was. He got charged with occupying a place in a vehicle that doesn't have a seatbelt. So a $240 fine for him. And then the vehicle was also impounded for 14 days, and there was an automatic 30-day on-the-spot license suspension.
Yeah, Ontario is heavy duty on those immediate license suspensions.
Yep. Which makes it all the more reason not to do stupid things in Ontario behind the wheel of a vehicle.
Well, I see stupid things every day, and I've been on Mike Smith talking about stupid things a lot lately and posted a few TikToks about stupid things. And the more I look, the more I realize how so often it's the stupid things that get people into trouble, not the mistakes. That lead to collisions. There's mistakes we all make, and sometimes you're not paying attention, and sometimes you misjudge something, but very often I'm seeing the stupid things. Lots of unsafe U-turns out there. Who was I seeing the other day? Somebody on was I forget. Oh yeah. It was the fellow who put the most miles of any on a passenger vehicle. He had been interviewed once, and he said one of the things that he did was he never made a U-turn. And that's the reason that he's never been T-boned.
I mean, I T-boned somebody who wasn't making a U-turn.
I know, but, it does increase the likelihood. Sue, Friday.
Friday. There you go.
Steak weekend. I'd like to have a T-bone, but with inflation being what it is, it's going to be ground beef.
Chuck.
Exactly.
Well, that's our podcast. On that depressing note, it's donut day. Go have a donut. That'll cheer you up. And if you need to reach us related to a driving law related issue, you can find us online at vancouvercriminallaw.com or give us a call at 604-685-8889 and tune in next week for another exciting episode of Driving Law.